Go bold at boldip.com.
Hey everybody, welcome to the Bold Inventor Show. I'm JD Houvener, your host, owner here at Bold Patents Law Firm. I've got our special co-host, David Bosland at Bosland Law. Welcome.
Thank you. Extra special co-host. I did pay you that $20, remember?
You are, man. And you've even been on our regular show as an active participant. So thank you doubly. Sort of filling in for Matt Colseth, who's on an extended vacation. He's wrapping up. So he did hunting for 2 weeks, and now I found he's in Italy. So he's really covering some ground. Apparently survived the hunting. Let's see if he survives Italy.
I love how you just said, and I found out he's in Italy.
Yeah. Well, yeah, he did respond. He has a lot. He's doing some responses to me, maybe just to me. I feel special.
Yeah.
But to his clients, I think he's still unavailable.
Yeah.
Yeah.
It's a whole nother topic, but it's like, should you retire? The classic concept of retiring is work your butt off until you're, X age and then quit. I have no intention. My head's going to bounce off my desk.
Yeah.
But I take big chunks of time off like that during the year, and I'm just going to keep doing it because I enjoy this work.
Yeah. This is what fills you up.
Yeah. You bet.
Perfect. Well, we have a good show today. I'm glad to have you helping me kind of keep things moving along, keep expanding, keeping me focused. I think we have 7 questions we're going to get through, and then we're going to talk about our topic, of course, today.
Cool.
Patents versus trade secrets, head-to-head. Unveiled. So really kind of just where do they meet? How are they friends? Maybe how are they enemies? But mostly just more about them.
Yeah. When I logged in just a few minutes ago, I totally read that as patents versus trade, secrets unveiled.
Oh.
And then I went, hang on a second, man.
Yeah.
Patents versus trade secrets unveiled. Being dyslexic is a never-ending source of joy and amusement.
It is. Now that you say that, I think someone could totally see it. You almost want to have like a hyphen, trade secrets or something to keep those words connected.
Partly, it's because and this is I'm being serious. Patents is something people recognize. They recognize the word, even if they don't have a lot of detail about what it is. Trade secrets. Walk up to most of the attorneys that you know and say, "Hey, what's a trade secret?" They'll be like, "A what?"
Right.
Yeah. So if people who are watching go, "Well, I'm not really sure what a trade secret is," I'm sure we'll get to that, but don't feel bad.
Yeah, exactly. This is it's that there's so many of us attorneys spend our entire career within just one specific niche. There's so much going on, so many different fields within the industry. One quick disclaimer before we get too far along. We're both attorneys here, but we're not offering legal advice. Of course, this is our fun time. We get to just talk about legal information. We get to answer hypothetical questions and some real questions from our audience. If you're on live, you're welcome to ask a question, but please don't share anything confidential. This is not the place to do that. We will provide a link before we end our show to get a hold of us. And I've got a brand new inventor kit I'm promoting, if you will. It's a quick downloadable PDF, and it's a lot easier. We find that a lot of people that are just kind of like, oh, I don't know, what is this all about? They're much more likely to download a PDF and get some education before scheduling time with an attorney. So look for that link later for the Bold Inventor Kit. And, we were going to do some questions, Q&A first, and then we'll do our patents and trade secrets discussion, probably for, the middle part. And we'll wrap up with a bold bite where I've got a Shark Tank pitch for a unique product, for an eco-friendly, environmentally friendly product, and we get to see our take on it from an IP perspective. So hang in there for that. If you're watching this after the fact and you missed us, we are live every week, every Wednesday. I try to be at 1:30 Pacific, so 4:30 Eastern. Come check us out. We're on for between a half hour and an hour, and it's your time to go check us out, participate, ask a question, and get involved. All right, that's my spiel. Let's get to some questions. We found this never-ending bucket of questions in our Reddit patents and trademarks. And you mentioned you've got the trademark watchdog on Facebook. Maybe we should bring some of those questions here if you have any next time we have you on. But
yeah, it's great. That's great. It's cool. A lot of people in there are crafters and creators, or people that are producing stuff and trying to sell it.
Yep.
And that's one of those places where things like copyright and trademark come up a lot. So it's a little over 40,000 people trying to keep themselves on the straight path with respect to their IP. So it's just great to see people that interested in this very, very important part of their business,
Love it. All right, let's get ready. It's live Q&A time. Well, I mean, it's basically live. These are preloaded questions, but I haven't actually reviewed them. And David, you have not either. So you're on the ball. I'm only 16 and never did anything related to selling. I had an idea similar to satin lined beanies, and speaking of creators, right? I wanted to create a product for it. Where do I go? How do I go about building a prototype? How would I mass sell it? Is it possible for someone under 16 to create and sell a product, or only for adults at age 18 and up? Lots of questions there. I have so many questions. Can someone give me an in-depth answer? Oh my goodness. Lots of places to go there. Do you want to kick us off on this?
Oh, yeah, that was a wobbly pass. But yeah, gosh. So I'm going to find an easy question in there. It's like, can somebody 16 kind of create something? That's not quite what you're asking, I don't think. But the answer to that is absolutely yes. But if I'm 16 and I can only sell it to people who are 18 and over, right? Maybe it's I'm not completely sure about this case, but think about something, a smoking apparatus, like the cigarette holder that's this long, right. Something like that. It's like, it can't be sold to somebody under 18. I think you can still create that. You can still invent that. You might have to work with somebody else to maybe put that through a site or some other location where it's 18 and up, need to be involved, et cetera. But there's really no reason in my mind that you can't be the creator of it. You may run into some struggles when you start getting into contracts and things like that. It kind of depends on where you sign that contract, because the age of majority isn't the same everywhere. And you could be asking this question from absolutely anywhere. So as far as like, I've got the idea, I'd like to do this, absolutely correct. But there might be some of those things you need to work through.
Yeah.
What about JD? What about prototypes? Let's just talk about a cigarette holder that you've got a great idea for. Instead of being straight like Penguin did, maybe it goes like this or something. Just as an example, because I'm curious, come up with something and I want to make a prototype. I can barely make my own TV cabinet that we were just talking about a minute ago.
Yep.
I don't know.
Well, yeah, a few things here. I mean, to me, the age thing is pretty cool. Classic case of, it's true that to be an inventor, you don't need to be an adult. You can be any age to be an inventor named at the patent office. The later questions, I think, go to what you were talking about in terms of how you're going to be able to transact, contracts, having ownership. Ownership may be an interesting question. If you have, certainly you can open up a bank account and you can have access to money. You can likely sell, but you can't really, I don't believe, execute contracts, to be able to list them online, say at Amazon.com, for example, or to engage in legal contracts. You might be limited or reduced. So I think it may be wise to consider bringing on a partner, maybe even a parent or someone who's of age who can work with you and be a part of your business. Set up an entity. It's a common recommendation I make when you're going to be engaging in, even with a third-party prototyper or designer. Usually wise to have a contract in place to maintain confidentiality. And again, you're going to probably want to have someone on your team that's an adult. They can, sign that contract, make sure that's going to be binding and enforceable on anyone who might breach it. But satin lined beanies, I don't know much about that industry or what you've created, but if you think it is unique and you think there's a big enough market for these types of beanies, right? This is, I assume, a beanie you wear, satin lined, maybe it's got less friction, or, it has a bit of a sleek look. Hats are huge. I mean, maybe there's a big enough market that would warrant investigation to see if it's patentable. And when it comes to apparel, I think about design patents. It's sort of an easy, at least initially, lower investment. But what you have is functional benefit. Like I said, if it has lower friction, if there's some way to actually provide, additional warmth or some benefit utility to the hat, you can for patent protection as well for that. Yeah, lots of questions there, lots of places we could go in further. So we'll stop there for now. All right, so here's one. This is out of Quora. I like it. It's simple. How do I figure out if my idea is patentable? And this is a great question. So patentability, I usually explain it in terms of two major hurdles to clear. The first one is eligibility. So do you have an invention that is even eligible? Does even fit in the ballpark of the patent law? And so most things are. Most creations, innovations are. Those that are excluded are those that are more natural phenomena, right? Things that are part of nature. DNA itself, right? Equations, right? Laws of physics. Things like that will be not eligible, even though you may have discovered a brand new principle, right? A new understanding of the world or of space, right? That discovery, while fascinating and amazing, is not something you can personally own. So that's what the patent law says. There's also another carve out for abstract ideas, where really there's no tangible way to say, yep, that's what it is, where you can actually point to it and explain where and how it exists, and to where, honestly, you'd be able to enforce it against an infringer. And so those are the areas to talk about with eligibility. So once you clear that hurdle, it's about patentability and whether you can get a patent on it. And there's three major criteria for functional utility, and that's you have to be novel, right? First of its kind ever. And that's not just what's been patented before, but what's been published forever and ever. And then the second big one is non-obvious. So even if it's brand new, first of its kind, no one's ever done it before, has there been any motivation or teaching or combination or suggestion that there's a way you could combine previous prior art, previous developments or technologies in the past to create this new invention you come up with? So if you clear those two hurdles and you can prove also that it has a benefit, a utility, you're patentable, and you should probably file immediately. So that's my quick, hopefully not too long explanation on patentability. David, would you offer anything else?
Only just that the non-obviousness of it is one of the trickier things, I feel, when you're trying to evaluate it. It's like, well, I think of a doorknob, and they all tend to be shiny, brassy looking, whatever. And I come out of the rain and my hand slips on it. So putting some texture on it, just a little bit of texture to give them just a little bit more grip. That might be non-obvious.
Yeah. Or
that might actually be a little obvious. It's one of these things where sometimes it depends on how you describe it, or when you're looking at something and you're going, I see. I can see how that would be obvious. I can make it a little different. Right? You're the one that came up with it. So if you can go, all right, okay. So we're not going to pursue with that patent, but I know how to change it just a little bit better, a little bit more, and then it is non-obvious, and you can proceed forward. So don't just throw it out. Recognize that this obviousness concept, is difficult as it is for people who really know what it is to explain.
Yeah.
Don't just stop there, I guess is what I'm saying, because that's a tricky spot.
Yes, totally. Yeah, I would say work with someone who's got experience. And in those cases where it's close, where you're combining three or more, two or more pieces of prior art, it may very well be worth to just file. Work with the examiner, work on the claims, and get the claim scope. All right, this one's on the trademark side. A little bit lengthy. I gave an example. They've registered a character trademark for Shaver Shebang, which is a class 3 cleaner for use on electric shavers. We will soon be launching a new version that we want to call Shaver Shebang Supra. There's an active character mark for Supra, which is class 3 for liquid soap, with the addition of the word Supra, infringe. So a very specific question here.
It's a very pointed question, and this question calls out, class 003 is often the way that it's listed, 3 numbers, but cleaner for electric shavers, liquid soap just for cleaning things like soap cleaners and stuff like that. These categories tend to be fairly broad, and I'll point out, tend to be non-obvious at times, right? So you kind of need to go and look it up, and there are places, and we can provide links or whatever later, that says, here's what's in this class 003. Oh, okay. And here's specifically what's not in the class to try and help define what the class is, right? Because you can't just give it a title and go, oh, well, I know what goes in there. It's soap. Well, right. No, it's cleaners, right? Anyway, so you've listed the one class. You've already got a name. I'll just say it's a registered trademark that you have.
Right.
I'm just gonna go ahead and state that. You're thinking about adding another one, and you're going to add this, right? Kind of like adding another beer. If I'm a brewery, I've got the name of my brewery, and I've got a lager, but I'm going to do an IPA, and it might even be an additive title or something like that. So these are all trademarks. As soon as you've got the second beer, you've got 3 trademarks. So you're in the right spot, and you're asking the right questions. It's a very interesting question, because you're saying, I've already got this name, but this other component of the name I'm considering also already exists in the same class for something slightly different. Here's essentially the answer. The trademarks need to be considered in their entirety, right? And you look at a trademark and you've got some words, or it might be a logo or what have you, but the analysis isn't exactly on those words. It's on something called the commercial impression. So, well, what the hell is a commercial impression, David? You're confusing me even more. Well, think about it this way. Think about a bottle of wine called Elephant and another bottle of wine with a picture of an elephant on it. The word and the picture are vastly different things, right? If we hold them together, you go, well, that's this one and this one. They're not the same. Those are clearly different manufacturers of wine, whatever. But that's not how they do the analysis. It's not side by side. It's like I'm looking at this word, and then we're assuming that I tell JD this was great, and he goes to the store and he buys a bottle of wine with an elephant on it, and it's garbage, and then we never talk again, right? So you have to take the whole thing into consideration. So in this case, you've got the first 2 words and then adding Supra. The concern is there's another registration for Supra. The question then is going to be, are they different enough? The whole thing is based on confusion. Would a consumer be confused if both of those marks were used in related goods, sufficiently related goods? So then, even though those marks must be considered in their entirety, they can have a primary component. I'll just call it a primary component to that mark, right? So if you add an S and make a mark plural, the primary piece of it is the same, even though they're different marks.
Yep.
Patent versus patents. Those are different, objectively different, but it's kind of a subjective analysis. So they look at, well, what's the primary part? The primary part is patent, and so you end up being denied. So in this case, those words come before Supra. Supra is just says, hey, it means like better or first or that kind of thing. It's suggesting that. I would call the primary component shaver shebang, not Supra. You might run into trouble if Supra is like super famous, like right. Gucci. If you said, shebang Gucci, they might go, oh, well, kind of Gucci's the primary piece in the mark you're suggesting, and so it's not going to work. I don't think that's the case here. I would look into it more. Of course, if I was going to actually give you legal advice, which we aren't doing, I would do a little bit more of a deep dive. But just based on what we have in the question and how trademark law works, you're looking at your primary component. You can't really mess up a mark by adding some smaller component that's already registered. So
Okay.
it's a complicated thing. It
Yes,
really is.
totally.
But
No, I think so. It sounds like the answer is
I'm not terribly worried.
not terribly worried. You should hire counsel to dig into it. It was a great thing for them to sort of stop and ask.
Great
about
question.
it. Okay, we got a few more here. Let's do it. This is an interesting one. I like it. It kind of brings me back to law school, ish. So, can I be sued for selling a copyright patented product if I purchased it?
Absolutely. I can sue you for any ridiculous reason I want to. The question really is, would that suit be successful or even sustained in court, or just kicked straight the hell out?
Yeah. Yeah.
So that's the real question, right?
That's a real question. Yeah. So it's
What do
a
you think?
copyrighted product, copyrighted, patented. Those are different things. I think they're sort of, by putting the slash, they're saying that those are similar. And so there's some confusion there. So copyright, just as a high level, protects works of art that are fixed in a tangible means, something you can touch and feel, held and defined within a fixed manner. So you can look at it, listen to it, look at it all, and it's part of someone's own creation, right? But there's on the patent side, we just talked about the big three requirements. It has to be unique, novel, non-obvious, and for utility patents, it has to have utility. So two separate things, two separate offices. The Library of Congress will register a copyright, and the United States Patent and Trademark Office will issue patents. So not the same thing. But let's talk about, I'll do patents. You can do this.
That's a great idea.
So if you sell a patented product, if it's enforceable, that is an infringement. That is one of the 4 rights you have as a patent holder, is you have the ability to exclude anyone else from making, using, selling, or importing your patented within the claim scope of rights. So even though someone bought a product, they do not have the right to resell or to sell it, make a profit from it. So that's my quick answer for that. If you have anything more to talk about on the copyright side or elaborations.
Yeah, absolutely. There are some cases where you can run into just to continue a little bit with patents, like patent exhaustion, right? Meta part cases and things like that, where it was decided that, well, you bought a product and then you rinsed it and sold it, or whatever, right? So it's another space where that can get a little confusing.
Yeah.
But there's a similar concept then with copyright. And for a copyright, let's just call it a book, right? I went to the bookstore, I bought a book. That's a very old thing to say. I went to Amazon, I bought a book. And so now I own that book, that physical copy of that book. Now that's called the first sale doctrine. It's the same thing, really,
right,
functionally, but it's called the first sale doctrine. That is where the copyright holder's rights end. That's where they terminate. Once I sell you a book, I can buy it. I can sell it to JD. The copyright holder can't keep me from doing that.
Right.
Very near to that is the idea of derivatives. So if I take that book and I kind of make it into something else, and I could spend the rest of the day talking about, well, what do you mean by make it into something else, right? How many John Wick movies are there? So if I took the first John Wick movie and made John Wick 2 myself, that's going to be a derivative work. I'm not allowed to do that. But if I bought a copy of John Wick 1, I can sell that to JD. So I bought it, but because of the first sale doctrine, I can sell my copy. Now I don't have it anymore. JD has it. The copyright holder hasn't lost out on anything. They did sell a copy. They sold a copy of the book or copy, whatever it is. But I can't go and print multiples of them and start selling them to all my friends. That I can't do.
Right. Okay. That's the same for patents too. I think that's what you're saying about exhaustion. Like, if I invented this water bottle, it's patented, and I sell it to you, this one actual water bottle. The one.
That one.
You can actually turn around and sell this for whatever you want.
But I can't go make them anymore and start selling. Right. I can't
correct it. And that's why software you rarely will buy software like Microsoft Outlook, right? It's a license, the EULA, right? The end user license agreement. I think probably for that reason, right? They don't want you to be able to sell it or have whatever rights. They want to be able to keep you paying the subscriptions because you're not actually buying the software.
Yeah, like Microsoft Word. Microsoft Word used to come on a CD. If anybody remembers, it's a CD. It's not a heart. It's a CD. I could sell JD that CD. Nobody can keep me from selling that CD. I now no longer have that copy of Word. JD has it.
Yeah,
he's over there. JD has it. So that works. And for a long time, it wasn't an issue because it all came on physical media, and that's just almost non-existent anymore. So you have to have end user licenses, software as a service. That's just the way. I mean, right now, if you want Word, it's a subscription, right? So they're selling subscriptions to the software. They just kind of changed the way that they provide that to you, and this is largely why.
Absolutely. Okay, we'll do one more, David, and then we're going to jump to our big topic for the day.
Cool.
Just want to be able to get through this one. This is a great one. I think this is a question asked by a lot of our clients, some of those clients that are kind of bootstrap, questioning, gosh, should I spend this much money to acquire a patent? So is it worth it to get a patent if you cannot afford to sue for infringement? Right. Oh, man. Well, okay. I'm a little biased. And I think it's interesting. It's a good question. Multi-layered here. Should you get a patent? I think that analysis of whether you take the jump, whether you invest, it could be 20, 30 grand or more. Hiring a professional attorney, law firm to get you a solid patent, develop a patent portfolio, several patents. Here's the question: is how big of a market is it? Okay. And how much, given the research, hopefully you're doing research and you hire them to do a patent search first, you think, yes, we could get ballpark this much of the market. Is there that much opportunity? Right? Is there enough opportunity there to go capture it? That's the initial question. You really, in my mind, because it can take years to acquire a patent, and because a lot of things can happen in terms of bringing on investors or bringing on a partner and money, right? The ability to sue and to enforce your rights, I think can, and if it's a successful product, will happen. And I think the later conversation, which I'm happy to have you chime in on, is, I would say it's probably 95. Well, I'm not a patent litigator. 95% of controversies settle, right? Settle well before they get to costly discovery, litigation, trial, that type of thing. And a lot of posturing. And if done well, even the small guy, small gal can win. Quick final note is I was just celebrating the success this year, I think it was. Maybe it was the end of last year. The maker within the Apple Watch, the oxygen sensor, fairly small company, and we're still talking $1 million+ company, caused Apple to no longer be able to import the watches through customs, I think for 6 months. So there are remedies other than a suit in federal court through the ITC, the International Trade Commission, to stop infringing articles at the border. So there's other ways to get remedies, right, through injunctions like that, posturing, threatening, getting more money. There's even litigation financing. I'll stop there. David, any comments on that?
Probably just one. When I read a sentence like this, it says, if you can't, I read the last part, the clause first, if you can't sue for infringement. So we'll assume that the first clause is yes, it's worth getting a patent for all of the other reasons it might not be worth getting a patent. So the patent is doing the patent, but the question here is, but I can't afford to sue for infringement. Your only other option is to not do it.
Right.
If it's worth doing, go do it. There is a way to afford to sue for infringement, even if it's just a contingency case, right? You can go to probably DLA Piper or anybody, and if you've got a solid case and there's money involved and there's damages, they'll just pick it up. They're going to walk away with 40% of the take, but you find somebody, those pugilists, they're going to go into court and they're going to make that money happen. And now it's not even a question of whether or not you could afford to sue for infringement. It's whether or not you can afford to lose 40% of the damages that are awarded. So going to court can be expensive, but most of the time, I just don't see that really getting in the way. Go back to whether or not it's worth getting the patent in the first place. And, we'll talk about trade secrets and some other things in a little bit. So we can make even that question more complicated because we've got skills. But I wouldn't let going to court for something. You can't afford to sue for infringement if you've got a solid case, and the patent is like one of the biggest pieces that makes it a solid case for you.
Beautiful, beautiful. All right, we've waited long enough. We've got a couple people, Kendon's on, just waiting to talk common law, trade secrets.
Oh yeah,
talking about patents. We're going to duke it out. Let's go at least 15 minutes on this topic. Where should we start? I use ChatGPT. I have a list of 10 topics to kind of dive in. So, do you have something specific you'd love to offer? Kick it off.
So let's do this. We've talked about patents and we've kind of described it in some detail, so people should understand what a patent actually is, at least in broad strokes. But again, who's going to know what a trade secret is? And JD just mentioned common law, and for the longest time, trade secrets were protected by common law, and that's still true. And when we say common law, we mean what's happening in the state. I'm in Washington. It might be different in California or Idaho. So common law, case built law, that kind of thing. And that was the case for trade secrets for a long time. There is now federal law for that. We may get into that in a minute. But what the hell is a trade secret in the first place?
Beautiful. Yes. Definitions.
Let's start with definitions, right? A trade secret, you shouldn't be too surprised. There are some really specific definitions, and now we're talking about legal hurdles to get over. Do I have a trade secret or not? We don't have the time to really unpack all of that.
Right.
But I think if I was going to boil it down to like 3 bullet points for what a trade secret is, it is information. Long pause, because it is essentially any kind of information. So you can see how all of a sudden this bubble includes patents, because patents are information. So think of anything that's information that is not commonly known, right? So 1, it's not commonly known. 2, it has value, economic value, potential or actual economic value. You don't have to have made any money off of it, but it has the potential for it. And then 3, reasonable steps have been taken to secure it. And when you combine, it's not generally known, and I've taken reasonable steps to secure it, that's the word secret, right? And in the middle, it has some value, that's the word trade. All right, so those are the 3 things, and that's a trade secret right there. So I think that'll be enough for us to have the rest of the discussion.
Yes.
But we could go
this is great
for a long time about how we legally define what a trade secret is. But Beautiful. If you remember those things, you're good.
Yes. So we have, I like, maybe we should talk about this. When someone has a creation, an innovation, individual or they're part of a company, a key question is, should I seek patent protection or trade secret protection? What's best for me now? And that is a perfect question. And there's an analysis that I like as part of that, which is the reverse engineerability, it's a mouthful, reverse engineerability test. So I'd like to start there, whether you kind of go down this path of, well, let's look toward patenting, or maybe we can keep as a trade secret. And before I get there, I do want to talk about the policy, right? The overall policy of patent law, the reason for it. And I talked to actually one of my videos I did going way back to the 1400s in Italy. I think it's Bettalucci. They were the designers in Florence. He got a very first patent where the Italian, anyway, they allowed him to have his own shipping channel to get these big heavy marble things there. Oh man, I'm going down a rabbit hole. But okay, let's focus back on reverse engineerability and the policy for patenting in the first place, which is to not have secret societies, to have a sharing of knowledge. Okay, the patent system, this is why they're kind of butting heads. The patent system wants everyone's ideas and innovations to be shared with everyone else. Okay, that is the number one policy reason. We're willing to give you 20 years of the government. The U.S. says, we're going to give you 20 years to exclude anyone else from making, using, or selling this invention. And thank you very much for telling us all how to do it. That's what the patent system is. Trade secrets kind of works against that. And then you're sort of hedging your bets. You're sort of saying, I'm going to hold back. I'm not going to share my knowledge, this information that I know is valuable, because I think I can make some financial gain before I publish it or before it's detected, either internally or as part of a process. And so you're kind of, that's sort of an anti-patent tactic. It is a not so friendly sharing tactic, right? It's a competitive tactic. So back to the reverse engineerability test, the widget that you're making, let's assume that you had some trade secret knowledge or process or materials in making that widget. As you get ready, as you sell that widget, if it goes to the customer, if the customer is just as smart as you are and they're an engineer themselves, would they be able to take apart that widget and find out how you made it, find out what materials and your quote trade secret process in so doing? If they could figure it out, you ought to look at patents, right? Look to protect with a patent, because someone a competitor will reverse engineer it and make it on their own. If you've not sought patent protection, you'll face competition soon, right? And so, but if not, okay, maybe if there's no way, you're certain, that there's no way they could do it. At Boeing, I used to talk about, there's some trade secret processes for making their composite airplane wing, for example, and heating temperatures, how long it's heated, the rotation of the fibers, right, to get the right structural, right, integrity, the right static or dynamic loads. I don't think they sought patents on all of those things. They probably kept some of that information as trade secret, because they're like, no way is anyone going to be able to know how long this thing was in the heater for, or how we cured this, because the adhesive disappears or whatever it is. There are certain ways and processes that you might believe to be not reverse engineerable, and you should keep those as trade secrets. So the question is, what risk do you take by keeping it as a trade secret? Number one risk, I would say, is someone else, independent from you, invents the same or very similar thing and files a patent on it, publishes it, and now I think a good case can be made that no longer is your trade secret not commonly known.
It gets worse.
It gets worse.
It gets worse because
you're infringing
now,
right?
You're infringing, and you've been doing it for 50 years. Even if they didn't reverse engineer it, they just came up with a thing, and it's almost spot on to what you're producing, but you didn't have a patent. You start to run into trouble there too, right? And but I think you're absolutely right. The base question, the threshold question, is when I make this widget, once I start selling the widget, the idea is that I'm making money off of selling the widget, because there's other ways to make money off my own widget.
Yeah.
I'm making money off of selling the widget. When that widget gets in somebody's hands, can they go, oh, I see what this is, and then go gin up their own? You're probably looking at patent, because, like JD is saying, that the carrot for a patent is a government-backed sponsored monopoly for decades.
Yep.
And in order to promote these arts, copyright and patents come from the U.S. Constitution in this country. They come from the U.S. Constitution. Trademark's not true, but those two, to promote the useful arts, go read the Constitution. It's a sleeper, but but it's good to know. So these are constitutional rights, essentially, that we have. They come from the Constitution to promote that. It really is, for now you get to sell it. At some point, other people can sell it, which is why drugs all have two names.
Yeah.
Because at some point, somebody's going to make Advil, and if we don't call it something else as a generic, they're just going to call it Advil, and now we've lost our trademark too.
One really cool thing the trade secrets has going for it, that patent certainly doesn't have, is there's no, of your three lists, let's go back to your three, novelty is not on here.
No.
Uniqueness is not on here. And it's actually in the name. It's funny, you practice this area of the law, and you realize it's right in the name. Trade secrets. Known in the trade. How fascinating is that? So, in fact, this came up, and I can share this. So, in plumbing, okay, plumbing is a trade. There's a, I don't want to say it. No, let's change it. There's certain order to how the pipes connect, and plumbers just know that. Trade, people in the trade, you just do it. It's kind of like you've been doing it for years. You just know to put a 45 and a 9 and an exchanger, right? Whatever the coupling, that order is just how you do it. That could very well be a trade secret, even though hundreds of other plumbers perform that same exact process. So long, because it's not everyone knows it. I mean, maybe all plumbers do.
You could have trade knowledge, which might be general enough knowledge, but you talk about all the couplers and all the plumbers do it and blah blah blah. But you've got Houvener plumbing and Bosland plumbing. Right. We end up producing the same thing, but JD does it in a third of the time, and I have no idea how. Right? Oh, I just did a thumbs up. That's cool. But I have no idea how. How does JD do that? It takes me 3 times as long to do the same thing that everybody knows. Well, he's not going to tell me. That is definitely a trade secret. There is economic value to me not telling, or JD not telling me how he does it in a third of the time, even when we end up with the exact same product at the end, right? So, I could have, nobody really knows what pants size I'm wearing, and I'm not going to stand up and help you, but that is a secret, and I don't tell anybody. But there's no economic value to it at all. So one of the 3 legs of the stool falls off, and it's not a trade secret anymore because I can't monetize the information about what size my pants are. So I think that's kind of where you're going, JD, is that it's it is in the trade, but there has to be economic value associated with it, and that economic value to me must be because it's a secret. If everybody knew it, the value is gone, right? So if it's just the sequence of couplers and reducers and expanders for your Venturi effect or blah blah blah, whatever it is, right? And everybody knows to do that, and it's the way they've been doing it since the 20s. Oh shit, it is the 20s. Oh my gosh, you're so old, David. We've been doing it the same way forever. We're just not using lead anymore. Then, but you find a way to do the same thing cheaper, faster, something else, and you don't want to tell anybody. Now it's a secret with economic value. But again, it's not a trade secret if I don't take the right steps, reasonable steps to keep it a secret. That's part of the definition, is I have to take those reasonable steps to keep it a trade secret. I can't just go, I know how to do it, but I have papers of how to do it scattered all over the place, and I invite people into the office and blah, blah, blah. And I'm simply not taking reasonable steps to keep it a secret. A secret isn't a secret if you don't keep it a secret. Yeah. So that's one of the third P's.
Yeah, are we roaring in the 20s? Are we still roaring again?
We're roaring again.
Oh my God. We have a few minutes left. Let's stay on that though. Yeah. Keeping it secret. I get my plumbing done a third of the time as Bosland does. How do I keep it secret? What do I do if I was, let's say one of my top plumbers goes and starts a competitive company and misappropriates, starts his new company using our company's trade secret, and he was not allowed to. Can't stop him from competing, let's say, like we're in most states like California, there's no non-compete clause, but I can perhaps go after him for misappropriation, for taking our trade secret. This company's known for doing the double twist, double-sided tape, whoop-de-doo trade secret form method for getting these couplers and pipes together quickly. How do I show to a court that I meet element 3, that I was keeping the secret?
So again, the basis of it is reasonable steps under the circumstances. So that then becomes sort of a question about, well, what's a reasonable step? And when because you bring up another good point, which is the primary way that this stuff was protected historically was in non-compete agreements and employment contracts and that type of thing. If you think of the employee as the carrier and the secret as the disease, if the employee can't go to another place, your secret can't make it to a competitor. That's how I've stopped it. Just recently this year, that the Federal Trade Commission said no non-competes, all 50 states.
Okay.
Done, right? And then they were immediately sued. So I'm sure we don't have that resolved yet, but the point there is that non-competes are softening. California, they're gone. So you can't wait until they resolve the 50 states FTC question on this to decide how you're going to take care of your trade secrets. You'd best start now, figure out what they are, and figure out what reasonable steps would be to keep them a secret. We talked a little earlier about prototyping.
Yeah.
I have a great idea. I don't know how to make that pipe that does this. I don't know I don't blow glass or whatever the process is, but I need one to show investors or to see if it's any marketability, a whole bunch of reasons. So I've got to work with them, and I've got a trade secret because I figured out a process, that I want to step through with the people who have the machines and the other expertise to run them and all of that. So now I need to work with them on like a non-compete agreement, some kind of contract. This might be one example of I did share the secret. So it's not a secret anymore, right? That's not true. It's still not generally known. It still has economic value. And I've taken reasonable steps to secure it through contract use and things like that. I had to have somebody else do it to get a prototype.
Yeah.
The way I protected my secret was reasonable under the circumstances. Now, if they run off and make it and start selling it, they've got real trouble, right?
Yeah.
So that there it is. I don't know how much time we have left.
That's perfect. We have about 9 minutes. I think we've covered
There's one other thing.
Yes.
No, there's probably dozens of other things, but there's one other thing that I was thinking about before we started. And we're talking patents versus trade secrets, but there's really patents and trade secrets as well, right? So here's a concept, and I'm going to come up with a scenario that might help maybe explain how they maybe work together, right? So let's say I'm an oral surgeon, as an example, just to pick something up, because dentist, oral surgeon, these folks actually do a fair bit of inventing and create a tool that's got a little bit different hook on it or whatever. So you've got an oral surgeon. She's great. She's really good at it. She has all these patients that have a particular problem, and she wants to get to a particular result with the patient. She's got that figured out in her head, but can't really do it without, just the right tool. So she needs this correct tool. Now, as soon as she makes one with this bent end on it, maybe she never shows anybody and just keeps it to herself, but she might also be able to monetize that thing by selling it. Now we're talking about a patent, probably, right? Because that's what I want to do, is I want to make them, but I'm also going to use it. I'm going to use it on patients with a particular problem to create a particular result, a particular outcome. And I have a process for that. I use this tool, but there's a process for it. If you don't use the tool in the right way, you're not going to get the same outcome. So that process, I can hang on to that as a trade secret as an oral surgeon who just created a product that I'm going to protect with a patent, and I still have a trade secret process that I'm not going to tell anybody. I'm going to keep that forever, right? As long, but somebody could figure it out. It's like, oh, if you do it just like this, you do get the result.
Yes.
All right. That's sort of the risk there. But once you've gone through that enough, and it's like from point A to point X are all of these steps, and it's going to be wicked tough for anybody to figure it out because it's not clear. I see the tool, I know what the problem was, and I can see the outcome, but I might not be able to reproduce that without knowing what that trade secret was. So there's all kinds of things that can support patents, and they can be in the same space. So it's not always an either or kind of question.
I love it. I want to talk for another hour because this is getting toward best mode requirement within the patent parlance. I will pause. I think that is for another day.
Sure. Yep.
But I love how we started with patents versus trade secrets, and we ended with patents and. I think that is the right result. If you're doing it right, you have both. You have both. Okay, let's do our bold bite. The last 5 minutes here. I'm going to share my screen. We'll do a quick take. Watch the pitch here. This is for a device, not quite a pipe, but it's kind of similar to a pipe being pitched here. I'm going to share screen. I'm going to change my audio. Okay. Ready, set, go.
Next into the tank is a solution to a growing environmental problem.
Hi, Sharks. My name's Emma.
And my name's Miles. We're offering 5% of our company, Final Straw, for $625,000.
Ooh. Sharks, maybe you've noticed that our oceans are filling up with plastic trash. Much of that trash is made of a seemingly harmless item, the plastic straw. Straws may not seem like a big deal to you, but they're one of the top items littering our beaches. And some of the more sensitive ocean creatures are pissed. What is this place? Shark Tank! Sharks, oh please. Oh, you think sharks are scary? I'm more freaked out by the 500 million straws we use every day in the US. Yeah, it's a big number to get your head around. Here's what it looks like every second.
Oh.
Sharks, this is 5,700 straws. This is how many straws we use every second in the US.
Plastic straws are going out of style. They're getting banned in cities and countries around the world.
We thought there had to be a better way to design the drinking straw. So we did. This is Final Straw. Final Straw is the world's first reusable, collapsible straw. It folds up and fits in a case the size of a car key and is small enough to go on your keychain or in your pocket.
The anti-plastic straw movement is growing rapidly, and we are at the forefront.
Sharks, the mermaids need our help. So, who wants to help us suck responsibly? with
The only way it's going to work. There's so much risk. Here's an offer for you. I'll do the $6.25. I want 10%, but I want a royalty of $2 a straw because you can afford it until I've got back 1.8 million. So I got a return on my money.
Okay.
You have a great mission. This problem needs to be solved. I mean, and seeing these straws just, it makes me sick.
This is one
Count to
It's
second.
sickening.
Yeah.
Well, what worries me though is changing consumer behavior. It's just, am I going to carry another box in my pocket?
It's not just carrying it. Before that, you've got to educate them and then get them to buy it.
Yeah, but for that, I'm out.
Yeah.
So I love your cause, and you are the straw whisperer, it sounds like. But, you know, listen, you're talking about $20 straws. And,
Sure.
you know, we're talking about 1% of the market would buy this at $20. The rest are sold in commercial use.
This isn't for commercial use. This is for
Right, but that's my point. I think that's your biggest challenge here, that 95% of the market are really just trying to get straws and not increase their cost of living. And that few will go to this, and you're not going to be able to scale as big as I think you can for this valuation, so I'm out.
Question marks in terms of the business side, the finances side, the online side. You seem to have done pretty well.
Well, and I think to the marketing, you know, what is so cool about our product is people's
gave you an
passion
offer.
behind it.
Don't talk your way out.
We got to
No,
talk
I'm not
business.
going to talk my way out of it. So, Mark, we really appreciate your offer. You know, the valuation gave us is $2 million, and we've already done more than that in sales in 2 months. So, what we'd like to offer you is $625,000 for 12.5%.
No, thank you. I'm out.
Okay, thank you.
Thank you, everyone.
All the best, guys.
Good luck.
All right, no deal. So it's a patented product. I did pull it up. This was issued as a design patent. I will show that off a little bit. David, go ahead and give us your take as I pull it up.
Yeah, so straws. There are solutions to the plastic straw problem, and it really is a problem. I remember many, many, many years ago going to a zoo with my children. Straws weren't allowed at all.
Wow.
So they talked about the straw problem being sort of an industrial problem. It's like it's the only thing you're going to see at McDonald's. It's the only thing you're going to see in the cafeteria. I don't really think that that's true. And I don't know when this was filmed, but there are plenty of places where that's been taken out of the equation, which results in things like paper straws, which are great for 2 sips and then they're gone, or metal straws that you like this that you have to clean. So I'm not really sure. In a sort of an industrial kind of sense, like cafeterias or restaurants or things like that, it's probably not going to be a foldable metal straw, probably not a metal straw at all, but probably more like a paper straw. There are some materials that just biodegrade, right? If you compost, you've got these biodegradable bags that you can put those composting materials in. You could maybe make something thicker and make it bigger, but it's still something just like pull out of a box, use, and toss. But it's not plastic. It's going to degrade fast. You could even put it in your composting bin. So I don't know. I think there might be other options, but it sure was a cool little thing. We might have lost JD. We've lost him. Are we still recording? Oh dear. But yeah, I mean, the Sharks brought up a good point. The point about this pitching to an investor's thing, and this is like speed pitching. Don't be afraid to walk away from an offer that doesn't fit your criteria. You do your math first and make sure that you know what it's worth. And if you don't find the people that are willing to sell it, consider moving on. Find somebody else. I'm going to assume JD got kicked out. Hopefully he can come back. And I'm sure we'll do a splice later. Could ping him. All right, well, I'm going to drop and see if he comes on and adds me back. Great talking to everyone. Thank you so much for joining and letting me take up your time.
boldip.com.